Welcome to the Brodies webinar entitled Natural Capital, the Changing Landscape. I'm your host, Clive Phillips, and I head the Rural Business and Natural Capital team at Brodies. It's only around 4 years ago, just before the pandemic, that the concept of natural capital emerged into mainstream conversations about land use. Even then, it was mostly in the abstract rather than actual situations. Since then, it's developed quite rapidly, and there is rarely a decision taken about land use or investment in land or into land which does not take natural capital into account. Natural capital opportunities, in the broadest sense of climate change mitigation and nature recovery, is now presenting real opportunities for landowners, investors, and markets. At Brodies, we've been building real experience from our involvement at every stage of major natural capital projects across Scotland and in the development of new nature market practices, guidance, and regulation. It is, of course, still a very nascent market, although there are real projects and real transactions happening. With recent developments such as the UK Spring Budget, the publication of the Land Reform Scotland Bill, and the Scottish Government's revised carbon emissions targets, the landscape is changing for natural capital opportunities for landowners, developers, and investors alike. And so we felt this was an opportune time to share our thoughts with you. We have a great lineup of speakers for you on 3 topics: Kirsty McPherson on land rights, Bob Langridge on tax, and Graham Leith on carbon codes and nature-based solutions. So I'm going to hand over, first of all, to Kirsty McPherson to talk about land rights.
Good afternoon. I'm Kirsty McPherson, partner with Brodies and co-head of the renewables practice. I also cover natural capital as it has a natural synergy with renewables. Today, I'm talking briefly about land rights in relation to natural capital. This can cover a lot of items, including peat management, peatland code, forestry schemes, woodland code, and biodiversity enhancement works. Less to say on the latter, given it is early days for biodiversity enhancement works. So there are a few things to consider: the form of agreement you enter into, what third-party consents may be required, and are there any standard securities to be granted? So next slide. Broadly speaking, we have seen 2 forms of agreement entered into: a personal agreement, and sometimes backed up by a standard security, a lease of the area of ground in question, and of course, you may prefer to buy the land, but I wasn't going to talk about the latter here. So which is preferable? It's probably down to the circumstances of each deal, both from a developer point of view and a landowner viewpoint. So some headline points to think about. The lease is probably more costly than a personal agreement. You've got to think about onward sale and succession. Both will occur at some point, but how likely is that to occur in the near future? A tricky discussion for a developer to initiate, so they probably have to analyze this for themselves and take a view. If it is perceived likely that a succession or a sale is imminent, then you're far more likely to go down the lease structure despite the extra costs. In addition, you need to think about land reform and whether or not the lease option is preferable, and Clive is going to speak a bit later on land reform. You've got tax considerations. Clearly, there's LBTT payable on the different structures. So remember to take tax advice and do the calculations on the different forms of documentation. Clearly, this is a developer consideration, and but the landowners should give some thought to BPR and APR, which Bob will cover in more detail. So Peatland Action, NatureScot, who are providing many of the grants for peatland works, and this is just one example, they are looking to take security over the land, and we are seeing this can be over both a lease and the underlying title. So do bear that in mind just from a time and cost perspective. And with that in mind, you might not want to go down the personal route and an additional security, because then if you're getting a grant from Peatland Action, you're going to have multiple securities. And you wouldn't wish to deal with a ranking agreement, and a landowner may already have a security in place to a bank for an overdraft, etc. It does add an extra layer of complexity and would delay an already slow process. With the woodland code agreements, what we've seen, they tend to be personal agreements and not necessarily backed up by standard security. So each different aspect of natural capital seems to be taking its own path. You also need to think through what rights and obligations each party is to carry out, who is carrying out the peatland restoration or woodland works, or in time the biodiversity enhancement works, and what rights does the landlord require, if any, over the land. They should require minimal rights to the land given the nature of the works, but again, it's a sensible, practical discussion. It may in time transpire that for each type of natural capital work, there is a preference as to which option is used. Of course, we have to remember that renewable operators are required in terms of planning to offer up biodiversity enhancement works as part of their planning application. This can take differing forms, but in the Highlands, we've seen the council require 10 times the area of land affected for development required for biodiversity enhancement works. That can be a huge area of ground and can conflict with what a landowner has planned for their own landholding. So again, it's just sitting back and thinking about it practically. If we move on to the next slide. And finally, the point I wanted to cover was third-party consents. So are there any agricultural tenants over which you're likely to have to resume land? Possibly unlikely given the nature of what you're doing on the land, i.e. for peatland code or forestry, but for biodiversity enhancement works, that may become more relevant. Also, you need to think about crofters. And again, I would say this is more likely in respect of the peatland code than other areas of natural capital works, or at least what we've seen to date. Here you need to consider what rights the crofters have. Of course, minerals are reserved to the landowner, but if you're doing restoration of peatland, it is likely to affect grazing. So I think you have to assume that the crofters will share in any proceeds of peatland schemes or wider schemes on their land. So arguably, you're probably looking at them sharing in this income in approximately 50% of any income streams. So you might be looking at a temporary resumption, or you might even have to go down a Section 19A application, which might be either consented or unconsented. And this is one of the formal processes through the Land Court in terms of the Crofting Acts. Clearly, if you have crofters, you'll want to get a lot more detailed advice. I've only skimmed the surface here. This is very much a whistle-stop tour of land rights, but hopefully gives you some insight into the various issues which might arise. And I will now pass over to Bob to talk about tax.
Thank you, Kirsty. Good afternoon, everybody. My name is Bob Langridge. I am a partner in Brodies' corporate tax team. And in that role, I deal with a number of tax matters, but an area that I have especially got a practice in is around forestry and natural capital investment. And I've dealt with a number of large funds now that are looking to trade in woodland carbon units. So the main message I want to leave you with today is that the tax treatment of carbon unit schemes, so at the moment that's the Woodland Carbon Code and the Peatland Carbon Code, is a work in progress. At the moment, there is no specific tax legislation that really tackles these schemes. And an important thing to know about these schemes is that from a regulatory perspective, they're what we would call a voluntary carbon scheme. That is to say, they are schemes where the units generated cannot be used in satisfying any obligations under an international treaty such as Kyoto or Paris. And this drives some of the stuff I'll talk about in a minute about VAT. So at the moment, with both the woodland scheme and the peatland scheme, because there is no specific legislation dealing with these from a tax perspective, we have to look at what the general tax law says and try and apply these to transactions involving these units. The other thing that tends to change with these and where we know change is forthcoming is with VAT, and I'll talk about that in a minute. But at the moment, HMRC takes the view that where you are selling units under the Woodland Carbon Code or the Peatland Code, these are outside the scope of VAT. HMRC's reasoning here is that because these are voluntary units, the transfer of a voluntary unit cannot represent an actual supply for business purposes. And if there's no supply, there's no VAT. Now, that is unfortunate that that's their view at the moment, because it means any entity that's operating one of those schemes is unable to fully recover the VAT it incurs on the setup. And indeed, if all that entity is doing is operating one of these schemes, so for example, if it is a special purpose vehicle set up solely to invest in woodland carbon code scheme, it's not going to be able to recover any VAT at all. Now, for those of you who were watching the budget earlier this year, you'll see that, number one, the government put out a response to a consultation that it set out in 2023 on the taxation of environmental land management and ecosystem services. We'll talk about some of the things coming out of that towards the end of the presentation when we do a little bit of horizon gazing. But also they have now announced, because this was an uncertain point, that where work is done to design and implement and operate a scheme under the Woodland Carbon Code or the Peatland Carbon Code, this would count as trading for business property relief purposes, which is one of the two main IHT reliefs that might be relevant to these schemes. So that is certainly a very welcome thing to come out of this consultation. If we move on to the next slide. In terms of the current position for the Woodland Carbon Code, this is quite different to how we would treat the Peatland Carbon Code. And the reason for that is that the Income Tax, Corporation Tax Acts in the UK have special rules governing the commercial occupation of woodlands in the UK. And that phrase is quite important. They don't talk about the sale of timber, they talk about the commercial occupation of woodlands. And the way these specific provisions operate is to effectively remove the commercial occupation of UK woodlands from income tax and corporation tax entirely. Now, this is a bit of a double-edged sword. It means that while you pay no income tax or corporation tax on the profits, it also means you cannot generate any losses, you cannot offset any expenditure, and you cannot claim any capital allowances for your capital outlays. And for the woodland carbon scheme, because this is commercial occupation of woodlands, our view, and indeed the prevailing industry view at the moment, is that the sale of what are called potentially issued units and woodland carbon units by the occupier of those woodlands should, number one, be treated as a trading activity and therefore within the scope of income tax or corporation tax. And two, it's commercial occupation of woodlands. I mean, it's very clearly commercial. It's done with a view to generating a profit from the sale of units and therefore should fall outside of tax. If you are at all interested in the history of the taxation of woodlands, and I appreciate that is a niche and minority sport, this is quite interesting because the reason woodlands are outside the scope of tax is because people were, investing in commercial woodlands in the 1970s, 1980s, generating enormous losses upfront, offsetting lots of taxable income, but knowing that they weren't going to see a return on that investment for another 30 years when the trees were ready for harvesting. And the government did not like this. So their solution was to remove woodlands from tax effectively altogether. However, under the woodland carbon scheme, it should be possible to generate returns more quickly, within 5 years potentially. And so that kind of pushes against the underlying rationale for this exemption. What's also interesting about this is that because the exemption from tax is effectively tied to being the occupier of the woodlands, it means that any secondary sellers active in the market, so anyone who buys woodland carbon units from someone operating a woodland and then on-sells them themselves in the marketplace, is going to be subject to tax. Another point just worth mentioning here, if you own woodlands and you lease them to a third party who operates a woodland carbon code scheme on those woodlands, then that rental stream is not going to benefit from the exemption, because as the landlord, you are not going to be viewed as the occupier for tax purposes. For capital gains tax, it's unlikely that the sale of units would be treated as a capital transaction unless they are sold with the actual forest themselves. And again, there are specific tax provisions about the sale of woodlands for capital gains tax. And very broadly, the government only taxes the increase in value of the land and not the increase in value of the trees. And there is at least a reasonable argument to be made that because the trees are the actual vehicles for the sequestration of carbon, that the value of any unsold units effectively adheres to that trees and should be outside of capital gains tax. Now, I'm not aware of this position having been tested by the government, and it's something that we expect to get a bit more clarity on in the next few years, and I'll talk about why in a moment. Next slide, please. The peatland carbon code, you'll notice this slide is a lot shorter, and that's because there are no specific provisions dealing with peatlands as yet in the UK tax code. Therefore, none of the woodland kind of exemptions are likely to apply. So where peatland restoration works are taking place, these are being unitized under the peatland carbon scheme, and those units sold, regardless of whether you treat the sale of those units as a trading activity or as some other form of activity, you're likely to see income tax or corporation tax falling due on the sales of those units at the prevailing rates. And you're unlikely to be able to carve out the value of any unsold units for capital gains tax purposes. But of course, the flip side of that, because you're not outside of tax on a peatland scheme, you should also be able to recognize losses, you should be able to deduct expenditure from the scheme, and you should be able to claim capital allowance on any significant outlays of plant and machinery incurred in operating that peatland reclaiming business. So the taxation of peatland units, on one hand, it appears worse, however, a bit of a silver lining with the ability to recognize expenses. However, again, this might get aligned with woodlands further down the line, and I'll talk about why. Next slide, please. On VAT, we know there is change coming down the tracks. HMRC recently announced this in their Revenue and Customs Brief number 7, 2024. Currently, as I mentioned before, the revenue treats the sale of voluntary units generated under these schemes as outside the scope of VAT, which, while it is nice for buyers of units, that restricts the ability of scheme operators to recover VAT on their costs. HMRC always maintained that this position would be the case until there was a more developed secondary market in those units. They now feel that there is, and therefore from the 1st of September this year, there are going to be a number of changes to the way that operates on unit sales. Number one, they are now going to be within the scope of VAT, and the default position is that they will be subject to the standard rate of VAT at 20%. However, the government is also going to amend what's called the terminal markets order. Terminal markets are where you would trade commodities, and normally these are real commodities, although emissions trading schemes units can also be traded on a terminal market. And the idea is that the government is going to change the terminal markets order to allow, amongst other things, for the sale of voluntary units on a terminal market. And where units are traded on a terminal market, they should be zero rated. So that will be charged at 0%. The good news for scheme operators, therefore, is provided you have your ducks in a row, you register for VAT, you will be able to charge VAT at either 20% or 0% on the sale of these units. And in either case, that will allow you to unlock VAT recovery on your costs. What's not yet certain is the revenue's view on whether a business buying one of these units for the purposes of insetting is going to be able to recover that VAT. And I think the best argument that I can come up with is that they should be able to. And there is quite an interesting case. It ran from 2016 from the tax tribunals up to 2019 when it was decided by the Supreme Court. So Supreme Court judgment should carry a lot of weight, and that is HMRC against Frank A. Smart and Sons Limited. And in this case, the Supreme Court held that the buyers of basic payment scheme entitlements were able to recover VAT, even though the purchase of these entitlements wasn't directly linked to any of the supplies made by a farming business. The courts held that it formed part of the overheads of that business and should therefore be recoverable. And I would expect the same kind of logic and the same kind of argument as set out in Smart to apply to a business buying units under one of these schemes. If we flip onto the next slide, looking even further ahead, one of the things that emerged from the consultation is the formation of what's known as the Environmental Land Management and Ecosystem Service Markets Working Group. That is a snappy title, but it is an HMRC working group made up of industry professionals, tax professionals, and revenue representatives. And its remit is to review the taxation of ecosystem services, sales of units under these schemes, and try and come up with a more cohesive way of dealing with the taxation of those. So amongst other things, I would expect them to start trying to align different kinds of carbon units rather than having this big disparity between woodlands on one hand and peatlands on the other. The other thing that we know is coming, although the details are still a bit uncertain, is that there's going to be an extension to IHT agricultural property relief from 2025, 1st April 2025, and that is going to recognize in some circumstances that environmental services use can qualify as agricultural use for the purposes of the relief. So landowners have two potential avenues, BPR or APR, that they can look at. I will now hand over to Graham to give you some more detail on the actual schemes themselves.
Thank you, Bob. So I'm Graham Leith. I'm a partner on the Rural Business and Natural Capital team at Brodies, and today I'm going to be talking about how natural capital projects in the UK are operating at the moment and the changes that we might see in this sector over the next decade or so. So in terms of directly monetising UK natural capital activity, we're currently focused on carbon sequestration, and specifically the Woodland Carbon Code and the Peatland Carbon Code. These codes are the quality assurance standards for woodland creation and peatland creation in the UK. Under the Woodland Code, the party carrying out the project must evidence that they have sequestered carbon dioxide from the atmosphere, or in the case of peatland, that they've reduced the amount of carbon dioxide that would otherwise have been generated by the peatland degradation. So that's very generally what the codes are designed to do and what they measure. A carbon unit will be issued in respect of every tonne of CO2, and those units can ultimately be reported by corporates as part of their UK voluntary carbon reporting and their net zero efforts. The codes contain rules designed to ensure that the carbon sequestration can be robustly evidenced, and also that the units are not generated from an activity that would have been happening in any event. So this additionality test needs to be satisfied, and the best example of this is when the Woodland Code guidance was updated in 2022, and that update effectively prevented conifer dominant schemes of productive forestry from registering under the code. The rationale for that change in the guidance was that such projects were commercially viable even without the income that would be generated from the sale of carbon units, and as such they should not be considered as having resulted in increased carbon sequestration as a consequence of registering under the code. The Woodland Code has been operating since 2011 and the Peatland Code since 2015, but it's really only in the last 5 years that we've seen an increase in the interest from landowners and buyers, really driven by a growing awareness of the opportunities and the potential value that can be generated from these types of projects. However, as interest has grown, challenges and obstacles to scaling up of the sector have become more apparent. One of those is the inherent compliance costs in terms of registration of the scheme and ongoing auditing of the projects as well. Professional advice and input is required for this process, and also for the contract for the eventual sale of the carbon units, if that's what the landowner chooses to do. There are several intermediaries and brokers operating in this sector, and each has its own business model, form of contract. There are economies of scale that can justify costs for projects over a certain size that can expect to generate significant income from the sales of the carbon units. However, we've seen some reluctance from landowners who have suitable land for smaller projects, but are put off by factors including a lack of understanding of what the codes are and what the obligations they might be taking on, as well as the potential for professional fees and costs. If we are to maximise carbon sequestration opportunities for all, then unlocking the potential of these smaller sites is essential. All landowners considering such projects will need to understand the risks and the liability that could result under the code, but critically under the contracts for the sale of units. There is potential for tension here between the legitimate interests of landowner and the purchaser of the units. The sale contracts will make provision for the commercial return to the landowners in terms of payment for units, but most will also contain a suite of obligations that are all designed to ensure that the project is implemented in a way that sequesters the carbon that a purchaser is expecting and has paid for. A landowner wishes to limit risks and liability to those factors that it can control and feel confident of being able to control, or at least can insure against. And then purchasers of units need to know that the products they are purchasing and factoring into their own carbon reporting strategy will be delivered on time and in the numbers required. So scaling of the market and the credibility of the units under the UK codes is dependent on this purchaser and market confidence. However, the reality is that storm and fire events, but also human error and unforeseen environmental factors, can all impact on carbon sequestration levels and timescales from a particular project. Currently, there is not an established insurance methodology or market to cover losses, and the allocation or the sharing of risk as between the landowner and purchaser is not straightforward and is not the same in every case. Saying that, the designers and the operators of the codes do recognise these issues and factor in a provision for under-delivery, as well as creating a buffer mechanism to ensure that those units that have been verified, which is essentially confirmation that the carbon has been sequestered, or an equivalent amount of carbon has been sequestered, but then are subsequently lost through fire or storm, will effectively be replenished by a buffer managed by Scottish Forestry and the Woodland Carbon Code that's comprised of 20% of units from all projects. Along with two other legal firms in Scotland and the operators of the codes, Brodies is involved in a project jointly funded under the Fern scheme by Nature Scot and the Heritage Lottery Fund. This project initially involves consultation with various stakeholder groups for landowners and purchasers of units, as well as others involved in the sector. And the output from the project will be template contracts for the purchase and sale of carbon units under both existing codes, with accompanying guidance explaining why certain clauses are used and what they're designed to achieve. It's intended that these template contracts will help generate confidence in the sector and encourage participation by sellers who might otherwise be put off by complexity or the exposure to professional costs. The stakeholder exercise is almost complete, and it has also identified an appetite within the purchaser and intermediary sector for standardised contracts, in the hope that this will all help promote consumer confidence. From a landowner's perspective, from the perspective of someone who's interested in taking one of these projects forward, it's essential that the concept of permanence is understood, as well as the impact on land value, either for securing a bank loan or realising value on sale. Generally, a landowner will maintain or even enhance land value if it retains all or a significant proportion of carbon units that can then be transferred to a subsequent purchase of the affected land. If all or most of the PIUs are sold early in the project and prior to the actual sequestration of the carbon, then the obligations under the corresponding sale contract relating to land maintenance and production of verified units will have to be transferred to the new owner of the land. These obligations might cover a period of 80 years or more, and it remains to be seen how these obligations will affect land values. But they will inevitably have a significant impact, and particularly when the new owner does not have the upside of future carbon income. So that's something to consider from the landowner side. Permanence of land use is perhaps more of a potential issue with woodland creation than peatland, where alternative land uses will be more limited. However, in the period since the Woodland Carbon Code was introduced in 2011, we've seen huge developments internationally, but also domestically, in our understanding of the myriad benefits of nature-based solutions to the climate emergency and the biodiversity crisis. Ownership and control of the land required to deliver these solutions is key, and the value in that should not be underestimated. Next slide, please. We're starting to hear more about the concepts of stacking and bundling as landowners and advisors start to consider what other roles land has in meeting environmental targets. Biodiversity net gain is well established in England, and landowners can realise significant value in enhancing biodiversity on their land to offset what has been lost through development, perhaps on their own land, but also on third-party land. And there's a real market for landowners who have land available that can deliver these biodiversity benefits. The new planning framework in Scotland, NPF4, is less prescriptive on delivery, but biodiversity enhancement is part of this framework. And as different local authorities start to formulate their own policies for ensuring this, we can expect that owners of land that can deliver biodiversity enhancement will become of increasing interest to developers. Separate from offsetting development impacts in biodiversity, the peatland programme are developing a biodiversity code, and they expect to complete that within the next year and then to start rolling it out. This is anticipated to operate within the same framework as the woodland and the peatland codes. And there are other carbon sequestration codes being developed at the moment. A hedgerow carbon code has been trialled, and that is expected to be brought forward, as is the seagrass carbon code, which is known as blue carbon. Of particular significance is the soil carbon code, given the scale of agricultural lands that can be affected and the impact that this might have on farming activity. Farmers who are looking at the soil carbon code will also need to reconcile this with opportunities, reconcile opportunities from this code with the increasing pressure that they're seeing in their produce supply agreements with their customers to demonstrate improved environmental outcomes in the farming activity. We expect all of these codes to make significant inroads within the next 2 years. And this is where we come back to the concepts of stacking and bundling. Stacking is where ecosystem benefits that are generated from separate or complementary activities on the same area of land are sold to separate buyers under separate contracts. And there's also the possibility there for some of the benefits to be retained by the landowner for future deployment. Bundling, alternatively, is where all ecosystem benefits and environmental enhancements are bundled together and then transferred to a single buyer. Either stacking or bundling, or some combination of them, is a valid course of action from a landowner perspective, so long as what is being sold is clearly understood and valued, and that becomes more difficult when new ecosystem services are being discovered and developed. The risk, therefore, is inadvertent bundling and giving up future opportunities that a landowner just had not considered. These issues should also be considered when entering into any land contract, such as a renewable energy lease option. By agreeing to provide a third party with exclusive use of a defined area for a long period of time, often decades, the landowner could be missing out on opportunities to use that land for other non-conflicting ecosystem services. The risk is that instead they're transferring the opportunity to the third party for no payment. The impact of the Land Reform Bill will inevitably have to be considered as part of any decision affecting use of rural land in Scotland, and natural capital projects are not immune from that. I'm now going to hand back to Clive, who has a few comments to make on that subject.
Thank you very much, Graham. Thank you to our speakers for their excellent presentations, packed with some really useful information. It's interesting to see how we're starting to see a body of tax law develop around this area of work. So just while the questions come in for the Q&A, I will mention recent land reform developments, which was touched on by Graham and Kirsty. The background being that the precursor to the recent legislative proposals was a consultation, Land Reform in a Net Zero Nation, seeking to connect land reform and the climate change challenge. In the consultation, it wasn't entirely clear what the linkage was going to be, other than greater community engagement in land use decisions. Following that consultation, the Land Reform Scotland Bill was issued in March of this year. It's not the focus of this webinar to discuss the bill in detail, but the key elements are greater community engagement and pre-notification procedures for transactions involving land over 3,000 hectares, potential lotting requirement for land over 1,000 hectares, a new compensation structure for resumption of land out of agricultural tenancies, plus the potential introduction of a new land use tenancy sitting somewhere to the side of mainstream agricultural tenancies. We've yet to see how much of this will make its way through the legislative process, but there's undoubtedly the potential for it to impact on the land market, and particularly on landscape scale natural capital projects. It potentially adds a new dimension, as Graham says, to consider, and a layer of uncertainty. It's undoubtedly the case that the potential impact of land reform will have to be factored into projects and may even constrain or indeed increase opportunities, depending on where you're coming from. One thing we do need in this sector is certainty, because markets require certainty to function effectively. So we have a few questions come in on the Q&A, so we've got a few minutes to take some of those. We have a couple. Bob, I'm going to pick on you first, actually, in relation to actually quite a few questions on tax.
Thanks,
the questions,
Clive.
yeah. So the question's really, not surprisingly, about VAT and projects which have started prior to September 2024. This was raised by a couple of people. And will this allow recovery for VAT, do you think? Maybe you don't know yet, but for projects that have already started or been implemented?
The answer is, Clive, that we don't know yet. The Revenue and Customs brief only came out a couple of weeks ago, and it doesn't contain anything on historical VAT recovery. And from a VAT perspective, this is quite an unusual situation, something that could be the mainstay of a business going from being out of scope to within scope. That's quite an odd thing to happen. In the absence of any specific legislation around this, I think the two things you would have to look at are, under the current law, it is possible for a business to backdate its VAT registration for up to 4 years. You could do this on a voluntary basis, but VAT registration is never a given, and it could be that HMRC would refuse a backdated VAT registration application for a scheme that predates September 2024. Even if you do get refused backdated registration, though, you can look at pre-registration VAT recovery. And under the current rules for goods, you can look back up to 4 years and recover VAT on goods, and up to 6 months to recover VAT on services. And you would think, at least at first blush, that if you do qualify for recovery under one of these headings, it should be 100% recovery. And that's specifically because they haven't gone from supplies under these schemes being exempt to vatable, but from being outside of scope, i.e. there is no supply, to vatable. So, I mean, it's a very good question, and watch this space, but it will depend somewhat on how the revenue view this. I expect they probably, particularly for schemes that haven't been making sales, will probably wind up being able to fully recover their VAT.
Interesting. Thank you very much. Graham, you were looking ahead to the future. You were talking about biodiversity, net gain, all of that. And of course, we don't have the same regulations in Scotland as they do in England. Looking ahead, do you think we might see some sort of scheme similar to Woodland Carbon Code and Peatland Code for things like biodiversity net gain, or do you see that as just remaining a more of a, well, the others are voluntary, but a much more voluntary offset?
I think the biodiversity code that's being looked at the moment is expected to operate much like the Woodlands Carbon Code and the Peatland Code. So yeah, I don't know the detail of that yet, but and clearly the metrics will be different there because it's not carbon sequestration that's being measured. So be interested to see what the detail of that looks like. But yeah, I mean, it's certainly the principle that biodiversity improvement should be capable of being monetized by a code separate from any development that might be having a detrimental effect on biodiversity is accepted. So yeah, just waiting to see the detail on that, really.
Thank you. Yeah. Another question for Bob, if you don't mind. There's a question about buying an existing scheme plus unsold units. Is a stamp duty on the price for the units?
So again, this is something we expect that the working group will eventually come to look at, because there's no kind of firm guidance on it. And so I would probably hark back to things like basic payment scheme entitlements as a good analog for these things. And our view to date is been that there isn't any stamp duty. So SDLT if you're in England, Northern Ireland, LTT if you're in Wales, or LBTT if you're in Scotland, on the price attributable to the units itself. But I think that would have to be clearly carved out in any kind of documentation that it was a separate price for any units that you were buying.
Okay, good. Right, we're getting close to the end of our allotted time. One final question, which I think we could probably quickly go around all the panelists on, which is, what's your number one piece of advice you would give to a landowner? But if you want, you can direct it to an investor who's considering taking forward a, let's call it a carbon sequestration project. Kirsty, do you want to have a go at that one first of all?
Yeah, I think very easy. I mean, make sure you take advice. I mean, don't just look at the one scheme you're getting advice on. Look at your land as a round. Take advice from the relevant professionals, and just, you know, take your time. You don't want to lose the scheme, but get proper advice.
Good, thank you. Graham, do you want to have a go at that?
Yeah, I would just add to what Kirsty said, that now is probably a good time to be thinking about it. So I would not hang around, and that's principally because from getting to the design stage to, if we're talking about woodland creation, from the design stage through to the first stage of verification, which is 5 years after planting, and then future verification stages, you know, it's a long project, and I think the units have are of particular interest to people who are looking to report by 2050. And given how long trees can take to grow, I don't think you want to hang around too long. And there's also a lot of interest in the sector at the moment anyway, so I think now's a very good time to be seriously looking at it.
Bob, last of all.
So I would say be aware that what you are doing with any of these schemes, and I'm thinking more of individuals here, it's inherently quite a long-term project. And therefore, you really want to think about, look ahead, think about the future. Are you going to be able to operate this for its entire lifespan? Is it something that's going to pass on to your family? Think about who's going to control it and how, what kind of vehicle perhaps you're going to use to operate it. Do you want to put this kind of thing in a company or a partnership to make it a bit more flexible and make it easier to pass on to future generations?
Good. Well, thank you very much, Bob. I'm sure you'll agree that this has been an incredibly interesting session. I found it interesting. I hope you have as well. Some good points coming out of the presentations and the Q&A, and particularly this idea that you want to look ahead, look at opportunities ahead, seize the moment now, but try not to snooker yourself for future opportunities. I think this point about stacking and bundling and all of that is all very very relevant. At Brodies, we're very happy to keep the conversation going, so please do keep in touch with any of our team. There's also the opportunity to sign up to our various e-bulletins, including the one focused on rural business and natural capital. We have a vast amount of resource available on our website, including a land reform hub for those who want to keep up to date with developments there. So finally, it just remains for me to thank our speakers and to you, our audience, for joining us today. I hope it's been useful and I wish you a good day. Thank you very much.